Hi, I am Tushar Bakshi, a startup advisor at Setindiabiz, where we provide tax, compliance and IPR services to businesses and startups across India. In this video, I will discuss the ways of closing an LLP, the meaning of striking off and winding up an LLP, the legal provisions of striking off an LLP, checklist to strike off an LLP, and the process and documents required to strike off an LLP. So let us begin without any delay. What are the ways to close a limited liability partnership? To close a limited liability partnership, the very first step is to identify if it is actively operating or has gone defunct. To do so, you must check three things. Firstly, whether the LLP is carrying out any business activities. Secondly, if it is conducting any business transaction. And thirdly, if it has any assets or liabilities in its name. If the above three conditions are fulfilled, then the LLP will be considered to be active, and if it does not, you can say that it might have gone inactive or defunct. Now, based on this very identification, you will be able to determine the method you can opt to close your LLP. Let me explain this a little. If an LLP has been inactive or defunct for a prolonged period of time, you can simply file an application to the Registrar of Companies and get its name struck off from the Registrar of Incorporated Companies and LLPs. However, if an actively operating LLP wants to shut down, the Registrar of Companies cannot be of any help. In that case, the LLP have to opt for an altogether different process of winding up and approach the National Company Law Tribunal for this purpose. But what is the need of having two different processes? To understand this, let me take you through both of them one by one. Winding up an LLP. Winding up is more of a complete and permanent closure applicable only to active LLPs. Permanent because once an LLP is wound up, its existence cannot be revived, and complete because before winding up, its assets are sold and liabilities are settled in such a way that there is absolutely no claim or counterclaim relating to the LLP remains valid. The procedure for winding up is somewhat legally complicated. The LLP needs to file a petition before the NCLT, which will subsequently initiate legal proceedings against it. The NCLT will examine if the LLP qualifies for being wound up and subsequently appoint an insolvency professional to liquidate all its assets and clear all its dues. Now, compare this with striking off. Striking off the LLP. Striking off is a rather temporary and partial closure of the LLP. Why temporary? Because even after being struck off, it can be reinstated to its normal status by the NCLT on an application by any affected stakeholder, and partial because even after being struck off, the LLP may accumulate certain liabilities which will have to be jointly paid off by all its designated partners. Additionally, the procedure for striking off was far simpler and easier than the legally intricate procedure of winding up. Legal provisions related to striking off an LLP. Rule 37 of the LLP Rules 2009 contains the eligibility criteria to strike off an LLP. Clauses 1A and 1B of Rule 37 puts forth two conditions, and even if one of these gets satisfied, the concerned LLP would be considered eligible for being struck off. So let us discuss these conditions in detail. Rule 37 1A states that if an LLP that has not carried out any business transaction for the past 2 years or more, the ROC can itself take suo motu action to strike it off. In such a case, the ROC will issue a notice to the concerned LLP and seek a reply from it. If the ROC finds the reply satisfactory, it may drop its decision of striking off. But if the ROC is unsatisfied with the reply, or if the LLP has failed to furnish any reply at all, the ROC will go ahead and strike the name of the LLP off its register. Rule 37(1)(b) lays down the conditions for the LLP to get struck off at its own will, stating that if the LLP has not carried out any business for the past 1 year or more, it can file an application in Form 24 to the ROC for getting struck off voluntarily. Simply meeting these criteria is not enough. There are few other tasks which have to be completed before the application for strike off is filed to the ROC. Let me list all those tasks one by one. Checklist to strike off an LLP. Before filing the application to strike off an LLP, you must ensure that 1. It is fulfilling the condition mentioned under Rule 37 of the LLP Rules 2009. 2. Its financial statements of the last 30 days show nil assets and liabilities. 3. It has not have filed its annual returns to the ROC for the period in which it was inactive or defunct. 4th, all partners of the LLP have given their consent to the decision of striking off the LLP. 5th, if the LLP has a current bank account, it must have been closed and the closure statement along with the closure letter have been obtained from the banker. 6th, LLP must have filed its annual returns in Form 11 and financial statements in Form 8 for the duration it had been actively operational. 7th, the DPIN and DSC of all the partners and designated partners are valid and active. And lastly, no litigation or tax assessment is pending in the name of the LLP. Once you are sure of these, you can finally begin the process of voluntarily striking off your LLP. Process of striking off an LLP. To strike off an LLP, you need to follow a few simple steps which I will now discuss one by one. Number 1. Documentation. The first step is always to arrange all the necessary documents beforehand. You are required to do so because documentation is considered to be the most important aspect of an application. Inaccuracy or inadequacy in filing the documents can lead to a total rejection of your application. So if you arrange all the documents beforehand, you will not only be able to prevent any hindrances in the later stages, but will also drastically be able to smoothen the entire filing process. To know about the documents required for striking off an LLP, wait till the end of this video. Step number 2. Obtaining the consent of all the partners. Once all the documents have been arranged, a meeting of all partners must be convened to approve the decision of striking off the LLP. Such approval must be obtained in the prescribed consent forms and will have to be submitted to the ROC at the time of filing the application. Step number 3. Surrender registrations and licenses. If the LLP has obtained any legal registration or licenses, they need to be surrendered. Now, there are some registration and licenses which can be surrendered before the LLP is struck off, and others that are surrendered only after the strike off is affected by the ROC. For instance, EPF registration, ESI registration, PAN, TAN, and Import-Export Code can be surrendered after the LLP is struck off, but GST registration needs to be surrendered before the application for strike off is filed to the ROC. Number 4. Close bank account and prepare financial statements. As I mentioned earlier, the current bank account opened in the name of the LLP needs to be closed before the application for striking off is filed. Subsequently, the bank closure letter and closing statements will also have to be obtained from the banker. The next step is to get a practicing chartered accountant to draft and certify the financial statements of the LLP. These must show nil assets and liabilities and cannot be older than 3 months from the date on which the application is to be filed. Step number 5. Prepare affidavits and indemnity bonds. All designated partners must prepare affidavits declaring the LLP's inactivity for the year mentioned in the application. The ROC will rely on these affidavit declarations while examining the eligibility of the LLP to get voluntarily struck off. Along with the affidavits, the designated partners will also have to prepare indemnity bonds, declaring collective responsibility to pay off the LLP's dues arising after it has been struck off. Both these documents must be drafted on stamp papers of appropriate value and must be signed by all the designated partners in the presence of public notary. The notary will later have to stamp both these documents. 6. Appoint authorized person. One of the designated partners needs to be authorized as the representative of the LLP for filing the application. For this, a partners meeting will have to be convened in which all the partners will appoint the concerned authorized representative. This authorized representative must have this DSC valid and active to sign the online application. Step number 7. File application. Finally, the last step is filing Form 24 to the ROC for striking off the LLP. The form is available online on the official website of Ministry of Corporate Affairs. You can download the form from here, fill it out manually and then upload its scanned copy on the site along with the scanned copies of all the necessary documents and the digital signature certificate of the authorized representative. Once everything is uploaded, the form can finally be submitted with the government fees of Rs 500. The submitted application will reach the ROC and after a thorough examination, it will get approved. Subsequently, the ROC will notify its intention to strike off the LLP in the official gazette. The notification will be active for a month, and meanwhile, if no objections are received from the general public against the ROC's decision to strike off the LLP, the strike off will finally get effected. With this, we come to the end of this process of striking off an LLP, but we are yet to discuss the list of required documents. The required documents for striking off the LLP. You require quite a handful of documents to strike off an LLP. Let me list them one by one. Number 1. Indemnity bonds drafted on a stamp paper, signed by all the designated partners and stamped by the public notary. 2. Affidavit declarations drafted on a stamp paper, signed by all the designated partners and stamped by the public notary. 3. Copies of consent of all partners approving a decision to strike off the LLP. 4. Statement of accounts of the LLP showing nil assets and liabilities duly certified by a practicing CA. 5th. Statements of pending litigations of the LLP, if any. 6th. Bank closure statement and bank closure letter. 7th. All ITRs and returns filed to the ROC when the LLP was active. And 8th. Authorization letter of the authorized representatives signed by all partners. With this, we have come to the end of this video. Hopefully, by now, you have complete knowledge on striking off an LLP in India. If you still have further questions, you can ask us in the comments below. And if you wish to learn more, you can simply visit our website or contact our expert startup advisors on call or WhatsApp. Links are given in the description box. And if you found this video helpful, hit the like button, share it with your friends and colleagues, and subscribe to our channel for more informative content ahead. Do not forget to click the notification bell so every time we post a new video, you are the first one to get notified. Thank you for watching. Watch other videos as well.